The case revolved around Mount Holly Township wanting to redevelop a part of its municipality that just happened to be predominantly African American and Hispanic. Their call for redevelopment was basically to use the state redevelopment laws to pretty much wipe out the entire community. The redevelopment plan called for a complete demolition of the existing homes, which included a number of African American and Hispanic homeowners. And because the law on its face appeared to be neutral, we had actually lost in state court. We lost an appeal on in the state court system. We also lost in federal court initially, but the Third Circuit Court of Appeals actually finally recognized we had a valid claim on behalf of our clients that the municipality, whether they intended or not, was acting in a way that was had a discriminatory impact. There weren't that many cases before then that had challenged redevelopment based on racial discrimination grounds, but it seemed clear to us that even if that wasn't what the township intended, that was the effect, and that we then used civil rights laws that were established during the 1960s to argue the case for our clients. There were 300 households that were living in the community with the Gardens neighborhood when we first started. By the time the litigation was settled, there were about 50 families remaining. And that was because it took about almost a 10-year struggle. And as I said earlier, that we had lost all the way up in state court. And it wasn't until we got a ruling from the Third Circuit that, which was about 7-8 years later after we first started the litigation, that things started to at least stabilize and then turn around. But we did work out a very favorable settlement for the remaining families, and our whole focus was not to get monetary compensation, but to have those families remain in the township and in the redeveloped community. The state of the law in New Jersey is that, and basically around the country, that if an area is deemed quote unquote blighted by a municipality, the municipality can pretty much do whatever it wants with in terms of its redevelopment plan, and the courts generally are not going to interfere and stop the municipality from going forward. So it was because we were able to use civil rights laws, the Federal Fair Housing Act mainly, that gave us a tool to have the courts intervene at that point, and specifically through the Third Circuit ruling, to at least give us some traction to work out and leverage to work out a favorable settlement for the remaining families. But it became very political because there was involvement with a year before, there was a similar case which had settled and had set off a firestorm politically because there was allegations that the Obama administration had intervened. There were same allegations made in our case. We had no contact whatsoever with the Obama administration or anyone political. We were focused exclusively on our clients and getting them, what was fair, and to keep as much of that community as remaining intact as possible. Initially, we had co-counseled with the AARP Foundation litigation from Washington, D.C. They were interested because a number of the households were senior citizens, in addition to being minority households. So right from the beginning, we had co-counseled with them. And we actually, towards the end of the litigation, there were some groups that became somewhat involved. There was one, the Institute for Justice, which was actually a conservative property rights group. They actually became our best ally. Their angle was more fighting eminent domain. but we were basically on the same page. And they actually, although didn't take a firm position on the racial discrimination aspect, they were adamant about this was an abuse of eminent domain. And they actually had written an amicus brief on our behalf in the Supreme Court, U.S. Supreme Court, when it was pending. Another organization that played a major role and helped us settle in the case was Fair Share Housing Center. They're the group that basically does all the Mount Laurel litigation, fair housing litigation throughout New Jersey, but they had volunteered to help us actually work out a settlement in the case. The two attorneys that were involved in almost a year of trying to help us settle the case were Kevin Walsh and Adam Gordon, and they helped us find funding from around the country and work out the actual terms, and we're able to bring the developer together, the township, our clients, and they put in an innumerable amount of hours without being compensated, and we're greatly indebted to them.